My name is Jennifer Kirschenbaum, and I'm here with Erica Youngerman and Richard Zimmerman. And it's our pleasure to speak with you about a topic that's very near and dear to our hearts, that we spend much of our time working on, and that is with residents and fellows on their first employment agreement. We are providing this educational webinar today because it's contract season. It's geared towards residents and fellows who are finishing up training. So for those of us who are listening that are more established or working with a practice or hospital in the contracting department, this is the advice that we tell your prospective employees. So certainly I could see how that would be useful, but again, the purpose and intent of today's seminar is for employees leaving training and tips for their first contracting process. We will be doing another webinar next week on employer concerns and issues in the contracting process, which we invite you to join us on as well. So to begin our discussion, I'll tell you what we're going to talk about today. We are mindful that this is a lunch seminar, and we'll try to wrap up within the hour so everyone can get back to it. We're going to talk about 3 different steps of the employment contracting process for residents and fellows. The first I'll cover is tips for evaluating potential employment and negotiating deal terms. This is our intro to the contracting process section. Our second area is the one probably of most concern for the majority of you leaving training, is compensation. And attorney Erica Youngerman will be addressing understanding your compensation to get what you actually need, not what you think that you want. And there's a big distinction there that she'll go through. The third step we're going to cover today, which Richard Zimmerman will be handling, is solidifying contract terms you are satisfied with and actually comprehend. And actually the comprehension part comes first, because if you don't understand your contract, you cannot know if you're satisfied with its terms. So I'm going to get started, but before I do, I'd like to highlight what you can call us about in case you do run into an issue, because we do handle employment agreements, but in addition to that, we handle all aspects of practice at our firm. We have over 15 attorneys in a number of different practice areas. Our healthcare department specifically works on audit issues from payers, and if you're a resident or fellow, these areas may not sound familiar yet, but they will. Healthcare compliance, HIPAA issues, Stark law, self-referral, anti-kickback, a lot of these things come into play with vendor relationships and third parties. Litigation, which we all hope to avoid at all costs, but sometimes comes up. Contractual issues, partnership, buy-in, selling, contracts with third parties. If you're going to work part-time somewhere else, you might have a license arrangement. Licensure problems with OPMC or OPD. Hopefully no one will receive a letter, but if you do, please do not call them back yourself. Collections issues, and general representation matters. So now that you have your laundry list and understand that you can pretty much call us with anything that comes up, and if we can't help you, we will certainly point you in the right direction, I'm going to get back into our topic for today. So that's me. Webinars are always difficult because it's a one-way situation. I thought it would be helpful to put up pictures so you can see who's speaking with you. Our tips for evaluating potential employment and negotiating deal terms is our first section. And I want to start by talking about a familiar phrase that we often forget. No se te ipsum, know yourself. That is the first piece of advice that I can give you before you start your employment contracting process. If you do not know what you actually want or what you're looking for, you cannot find yourself the right job. And that's something that I think we forget very quickly or maybe don't think about. Do you work well with others? Are you a team player? Are you more of a loner type where you're the boss, you want to be in charge, and you're not looking to be questioned? Think about these things before you start looking for a job, because the situation that you land in will hopefully be for long term. I can tell you that many of us do not spend enough time on this process, and that is why the majority of us do not stay at our first position, because we look at the interview process similar to dating. We're very nervous, we're worried about what the other party thinks of us, and we do not take the time for evaluating whether or not this is the right fit and whether or not we're going to stay long-term at this place. So think about what you want and the type of environment that you're looking for. Be truthful with yourself. How many hours are you willing to work? Are you a family person where you're prioritizing time for family and you want to make sure that you're not going to have extensive non-clinical time that you have to commit to? These are things that you want to know before you start interviewing, and at that point you will have a better understanding about whether or not you've found the right fit. In addition to understanding what you might actually be looking for, we also want to do our due diligence on practices or hospitals or any potential employment, because there's miscellaneous additionals. For instance, you could be taking a research position or going into academia, or possibly you're going into the business of medicine and going to work for a pharmaceutical company as a medical director. These positions are certainly abundant and available. Before we go into a potential employer, use your most valuable resource, which is, of course, Google. Try to see what you can find out about the individuals you might be working with and the company that you might be working with. We want to understand, if we can, profitability. And how do we do that? Well, that wouldn't be an outside search. That would be having a conversation with a potential employer and try to find out, are you replacing someone? Are you creating a new position? How much work is going to be available for you? Have they done fairly well in the past? Take a look around the office. Is this the type of place where you see that they're spending money on supplies? Does it look like the person you're interviewing with has been using the same pencil since 1972? These are the things that you want to consider. Malpractice claims, this you can find on the internet potentially. Or if you're working with an attorney, which of course you should be in this process, you can have your attorney do a quick search and see if the practice has come up or any of the owners in any potential suits or any licensure proceedings. Are you joining a place where the individuals have possibly been in trouble before? That weighs in on reputation, of course. Any other lawsuits? Now, why do we want to know about other lawsuits? In other words, a divorce or possibly an action with a contractor separate and apart from the practice. Well, that might have an impact on funding. If you are not joining a large employer, a hospital or a large group, if you're joining a solo or a smaller place, then some of the monies from outside activities may actually be coming from the practice, which would leave less money available potentially for you as you grow. Staff retention. This is a big concern because we want to stay where we start if we can, for the most part. So you want to know if the people that are working at this place are happy. Depending on the size, or not really depending on the size of the employer, staff retention may be an issue. If it's a large hospital system, oftentimes I hear concerns that administrative personnel have more power than a physician. And you want to be careful about that and find out, has there been turnover in the group? You can find this out just by having general conversations. Some of these questions you may not want to ask directly. Obviously, there's a bit of tact that comes into play when you're doing your due diligence, but be mindful of these areas when you're having conversations with a potential employer to try to help you evaluate whether or not this is a good place for you to be. Erica will talk about whether or not creating a new position or taking over for someone else will come into play with compensation, and you'll get that in a few minutes. So additional areas that I would like to cover before I turn over is, what are you looking for out of your employment? And by that I mean generally, because we're going to get more specific on terms and comp later, but as far as your expectations go, which is really what we're talking about now, your schedule, your call requirements, administrative versus clinical responsibilities and hours that you want to devote, because your schedule for clinical is not necessarily your entire commitment to your new employer. There may also be administrative or training elements that come into play, or research and publishing, and you want to get an idea on how much you're going to be working. Also, where are you going to be working? Credentialing and privileges, you want to get that information up front as well. and whether or not you're permitted to work at any outside activities. And I think Richard will get into some of these areas in a little bit more detail. For my purposes, I want to talk to you about the interview process and additional things that you should be asking about. Erica will talk in compensation about incentive comp. And what you want to know is what kind of transparency are you going to see? Whether you are joining a large facility or a smaller facility, you want to know that you're going to have the ability to look at your work product. How many patients are you seeing? Are you going to be entitled to a breakdown of the type of care that you're providing, especially now as we're moving towards a more qualitative type system where reimbursement is going to be on performance more so than services you're actually rendering by the number. So this all comes into play, and you want to get an idea before you commit on what level of communication you're going to have with the employer. Additional comments that I have for you, I'm just trying to rack my brain and see where I want to go before I turn this over. With your interview process is a question I get all the time, actually, is, Jennifer, what's the difference between negotiating between a hospital versus a private practice? Is it worth actually getting a lawyer? I don't think that any of my contract terms are negotiable. Well, I'll tell you this. Even if you're joining one of the largest hospital systems in this region or any other, we're based in New York, but anywhere in the country, which, by the way, we negotiate contracts all over the country, you may still have more power than you think. And you likely will be able to negotiate certain terms. Maybe not all, but I can tell you that I've had the least amount of success on a contract negotiation with a one-person practice, and I'm regularly able to modify a majority of terms with large systems. So just because you're joining a large system, yes, we may not be able to get you more vacation days because that might be locked in stone as a policy of let's say, a hospital. But there's oftentimes you're able to have a certain level of flexibility on the contract terms. And not only that, there may be provisions that are in the contract that you don't understand that would be prohibitive for you, so you need to consider whether or not you even want the position in the first place. So very important to understand and also know that you do have flexibility. Another comment that I like to give to my physicians when we're doing lectures or residency programs or fellowship programs is that you are more than your resume. And I say that specifically to the doctors as opposed to, let's say, lawyers if I were speaking to them about employment. You're coming out as the captain of your own ship. You are going to be 100% responsible for your patient care. You are a fully formed, fully developed physician, and no one is going to be there to protect you if you make a mistake clinically. So you should be going into your job interviews with a level of confidence, of course, and also, again, going back to our first slide, knowing yourself, bringing to the table your additional areas that you can offer. You're joining a community, so make sure that if you're very comfortable, let's say, with a certain EMR, and you notice the practice is possibly in transition to EMR, you should highlight that. Highlight different areas of your experience and training that are not necessarily showing on your resume. So these are our general tips that I wanted to cover today. I think that's just about it. If you have questions on this area, you can, of course, contact any one of the three of us who you're meeting today. I'm going to cede over the microphone to attorney Erica Youngerman, and she's going to talk to you about compensation.
Good afternoon, everyone. So I'm going to speak to you today about compensation, as compensation is not just your main form of salary or incentive comp. It goes beyond that. So compensation itself is actually a package. And a mistake that we often find that a lot of our clients make is looking just at the number. If they like the base salary, they say it's fine. Or the incentive compensation looks promising, so they think, okay, this is a good deal, or maybe it's better, actually, than another offer. But when you actually consider the entire package, there's a lot more to it. So here are just some examples of some of the things that make up the compensation package. And we will go through each of these in turn. So of course, salary and incentive pay, those are the two main elements. Benefits, expenses, insurance, right? Who's paying for the malpractice insurance and which elements of it, relocation costs in addition to signing bonuses, and time off. So we'll get through each of these in turn. Let's start first with the main element. What is our main aspect of our compensation? So commonly it's salary. So there might be a base compensation being offered to you. However, more and more, it's either going to be an alternative to a salary or some sort of hybrid where it's a salary combined with some sort of incentive package. So incentives can come in several forms. It can be based on a percentage of your collections. It can be based on your RVUs, so measuring your productivity, or it can be based on some other form of metric. So that can be patient satisfaction, quality, anything really that an employer can come up with. And there are definitely a variety of very creative ones that have been brought up before. So going on that premise, what do we recommend? The first and major recommendation we have here is that you always have a base compensation in place. Regardless of what else you're agreeing to, we always recommend having a base there that you feel comfortable with because, and we'll go through a number of factors of why this could happen, there is always the possibility under an incentive compensation model that you're going to take home nothing. So there always needs to be a situation where you have enough base compensation that you feel comfortable that you're being compensated for the work that you're doing. So we're going to go through a few factors as to why we recommend salary over incentive, but why, if you are doing incentive or if you're doing incentive as an add-on to a base, factors that you should be considering and making decisions about while you're negotiating for the job. So the first thing is your schedule. So in a lot of situations, as the new doctor in the office, you're not going to have a lot of control over your schedule. So who's deciding how many hours you're working, how many patients you're going to see, what types of patients are you going to see? Are you going to see all the lowest billing, follow-ups for other physicians in the practice, or you're going to really have a chance to grow and expand your patient base? All this is, of course, very relevant if you're being paid on an incentive model. Additionally, a lot of jobs come with administrative responsibilities, potentially supervision, or even teaching. So again, in those situations, that's all going to be time that you're working, but won't be factored in necessarily to the incentive model. So if you are being paid on an incentive situation, that needs to be considered and either addressed through the base compensation or through other metrics, such as the quality or satisfaction or some sort of promotion for hourly work for your teaching responsibilities. In addition to that, we have unpredictability. So when it comes to unpredictability, there is no way to know how much you're actually going to make in an incentive model, right? So of course, an employer can say to you, this is what we expect. These are the number of patients we have available for you to see. There's a lot of things going on there. The problem is there's no way to know for sure. So let's take a scenario where you place someone. So the employer says to you, this is a physician who has a full patient load where they're all going to be yours. You can just come right in and see these patients and take over. Well, here's the problem with that. The patients might follow the physician who's leaving, especially if the employer didn't have a strong non-solicit with that person. Or those patients may not choose to see you. They may have liked that physician particularly and just choose not to see someone else. Take the other situation where you're a new physician in the practice. You're not replacing anyone. Maybe the employer said, oh, there's definitely a need here. I'm very busy. I need extra help. Well, first off, especially in a smaller practice, you might have a situation where patients only feel comfortable with the main physician and are not willing to see his new associate. In addition, they may actually not need you. It may be that he misjudged how busy he was. It could have just been a busy month, and now all of a sudden they realize they don't have the patient flow. So those are things that you need to be keeping in mind. Timing of pay. How often are you actually going to get paid? So of course, with a base salary type model, you're going to have increments for payment. With incentive compensation, it's a little bit more complicated. We want to make sure that we have minimum increments that we're being paid on. In addition to that, what happens when you leave? So if you're being compensated based on collections, especially in light of the different specialties and how long it may take for collections to arrive, you need to consider that you may not be there when the collections arrive, in which case, are you getting compensated for those? Probably not. So that's something to keep in mind as well. Additionally is the reconciliation. So oftentimes when it comes to incentive compensation, you'll be paid maybe on a monthly basis or a quarterly basis based on anticipated collections, in which case maybe you have to repay it or maybe it's going to be offset in future payments. So again, this is why a base compensation is so important, because there may be months where you're actually not being paid. The next thing to consider when we talk about qualitative metrics, what are the factors? Who's deciding them and can they be changed? Oftentimes, in the actual contract, it will say that here are the following factors that we're going to consider. However, we can change them whenever we want. That is very common. So if you're meeting the factors, the employer could change them. And if you're not meeting the factors, they can strengthen it so that it's in favor of the ones that you're not meeting, right? So they can change the metric at any time. In addition, it's usually in their discretion whether or not you actually are meeting the factors. So the person who is incentivized to not have to have you meet those metrics, because then they have to pay you, gets to decide whether or not you do. Next big thing to consider is how complex is the payment structure. We've seen things such as 12-page compensation elements in the contract. This is very important to make sure you actually understand what you're signing, what you're agreeing to. And finally, on this topic of salary, and then we'll talk about some of the other elements of the package, what is your access to records? What is your right to dispute? So in that sense, if you are being paid based on your collections, what is your right to see what those collections actually are? In certain situations, you don't have any right. It may be a situation where you're handed a check and that's it. You want to be able to have access to see what those numbers are and potential to dispute it if you and your accountant disagree. So what are some other elements that we want to consider in our compensation package? What could potentially make a situation where two salaries that are exactly the same are not actually the same if you look at the whole package, because one might be much more valuable? So first off, is there any addition to the base compensation? So again, that incentive situation we just talked about, or discretionary bonuses where the practice is known for giving out bonuses on a regular basis. Relocation expenses. You may be talking about a difference of $5,000 between two jobs, but one requires relocation, and that relocation is going to cost you $10,000, $15,000. So that's something to keep in mind. Signing bonus, right? Of course, that's going to be considered as part of your overall compensation package. In addition to that, it may be very important to you to have that money up front for when you are relocating and starting a new position. Benefits. This is something, of course, that you're going to have to get on your own if the employer is not offering it to you. So this is a vital element of your compensation package. Examples, health, life, disability, 401k. There's a variety of different benefits that could potentially be offered both for you and your family. So these are things to definitely consider. Another big area that's often overlooked are your expenses. So these are things that normally you would have to pay for. And again, when you do the math and you really add them up, they might cause a significant difference between two different offers. So what type of things would we be talking about here? We could be talking about a car, the cost of the car itself, the cost of car payments, the cost of insurance for your car, gas, mileage, however you want to calculate it. There are a lot of costs that your employer may be willing to pay for. Your day-to-day things that are needed for the job. So a cell phone, a beeper, computer, things of that nature. Other expenses, your CME costs, licensure fees, hospital privileges, medical associations, the list go on and on. So these things, again, can add up significantly and are a huge element of your overall compensation package. Another element, vacation. How many days off do you get, and are they paid? This is definitely a big factor to consider when you're talking about these jobs. Next, insurance. So this is a big area, and this is a big expense that will really differentiate different jobs. Are they paying for insurance at all? That's the first question. Plenty of jobs we've seen, premiums are the responsibility of the employee. Okay, that is a huge cost that you'd be taking on as the employee. We always recommend trying to have your employer, of course, pay for your malpractice insurance since you're doing the work on their behalf. However, there's also differentiation between insurance policies that may be offered to you. The main two types are occurrence policy and claims-made policy. An occurrence policy is the more expensive policy. Of course, the policy we would advocate for employees to try and get from their employers, and probably the one you'll face the most resistance regarding. But this policy is covering you based on when the event occurred. So if the malpractice occurred while you were working at the practice and the claim comes in later on after you've moved on, it would still be covered by the policy. In contrast, the claims policy is when the claim was made. So if the claim comes in after you left the employment, you're no longer covered. So what would be important here? Getting tail insurance. And again, who's paying for it? Very, very commonly in these contracts, if it's a claims-made policy or there's no mention at all of what it's going to be, it will be a claims-made policy, they're not going to be responsible for tail. They're going to leave that for you. And oftentimes they'll even say you are responsible for getting it and proving to them that you have it immediately after you leave employment. So this is a huge cost that may be combined with other costs when you're relocating and looking for new employment at the end of this job. So definitely a big factor to keep in mind. So just kind of an example to kind of flesh this out to drive home the point of what I mean by looking beyond just the base salary, looking at the entire compensation package. So we have two new doctors, Dr. Abe and Dr. Brett. Dr. Abe is getting a base pay of $250,000, while Dr. Brett's only getting $200,000. So, you know, most physicians, when they first come to us, would say, clearly Dr. Abe is getting the better deal. That is what a lot of people do. And that is a huge mistake to make because there are a lot of other package elements that are here. And so here are just a few examples. So Dr. Abe is not getting any incentive pay, while Dr. Brett is eligible for 10% over $200,000 personal collections. How much that turns out to be, that's going to be very specific, of course, to the practice, to his personal performance. And what he can do there, of course, is try and find out from the practice their history, what other people have made, what the practice in general is making, to try and get an idea of what that could turn out to be. Benefit, Dr. Abe is getting single health insurance, while Dr. Brett's whole family is covered. Dr. Abe, this is a big difference, of course, claims-made insurance with no tail coverage, so he's going to be responsible for the tail, while Dr. Brett has occurrence and doesn't have to pay for tail insurance, and he has a relocation expense of $10,000. So at the end of the day, these two might actually be making the same, or Dr. Brett may actually be making significantly more, depending on how these numbers turn out. So the point here is to really look at the compensation package as a whole to make sure that we're digging deeper than just the main element of salary and really considering all these factors when we make our decision and negotiate with our employers. So at this point, I'm going to turn over the microphone here to Richard to talk to you about some other important deal terms to be looking for in the contract.
Hi, everybody. My name is Richard Zimmerman, and again, I'm going to talk about some more specific deal terms than what we've gone through so far. So first off, I just want to start by saying that, what we've gone through so far between Jennifer and Erica is more background and larger deal points that you're going to want to be concerned with when you're talking about your first employment agreement. But I want you to remember that the ultimate purpose of your contract is to spell out the what, where, and when of your employment. How is everything going to work? What's expected of you? And what can you expect of your employer in turn? Obviously, there are a lot of elements to that, but the first that I want to start off with is, well, in tandem, is the restrictive covenant and non-solicitation provisions. So I want to start off by saying that the purpose of each of these two provisions from your employer's perspective is that they want to keep you from stealing their business, ultimately. They don't want to hire someone who works for them for a year or more, forms all these patient relationships through the use of their resources, and then opens up shop across the street, takes all their patients, and now the employer is screwed. So these two provisions are the way that the employer keeps that from happening. First, the restrictive covenant, which restricts you by time and geography in where you can practice during and after termination. So what that will, the form that a restricted covenant will take is it'll say that during your employment and for some period of time afterwards, you can't work within a certain geographic range where the employer feels that you would become most of a threat. Similarly, the non-solicitation provision restricts your ability to solicit patients and staff and often all professional relationships of the employer. So that will say that during a certain duration, a certain time during and after your employment, you can't contact former patients of yours or patients of the employer and try to get them to leave and come with you. And similarly with employees, you can't leave, open up your new office, and talk to all your former coworkers with the employer and tell them, oh, you shouldn't be working for that employer anymore, you should work with me. Now, it would seem at first that the employer and your interests would be diametrically opposed in this. You want to be able to work in as many places and hire as many people and treat as many patients as you possibly can. and the employer is trying to take that away from you. And to a certain extent, that's true. But it's important to remember their goals in this as well, because when you start to negotiate these points, you can cut them down so that everybody is happy, or at least reasonably so. So to return back to our Dr. Abe and Dr. Brett example that Erica brought up just a minute ago, here are two different but similar restrictive covenants. So in the first one, Dr. Abe has agreed to a restrictive period for 2 years, where after termination, he cannot engage in the practice of medicine within 5 miles in any direction from any of the group's offices. So that means that any location, no matter how many the group has, Dr. Abe is restricted from working there. Dr. Brett, on the other hand, has agreed to a restriction that covers that same 2-year period and will not engage in the practice of medicine within 10 miles of any of the group's offices in which he performs at least 25% of his services on behalf of the group or the company here. Now, at first glance, it's not easy to tell which one of these is preferable, and often it will depend on the group. It'll depend on the company and how many offices they have, or are you afraid that they might expand while you're there? Because it's important to remember that when the restrictive covenant becomes effective, it'll be at the end of your employment. So if you sign a contract that says that you're going to be restricted from a certain mileage from any of the group's offices, that means that any new offices which are established during your employment will count towards that restriction. So what's difficult is that the restrictive area is very vague. So the question that we'll get all the time from clients and from doctors who are looking at agreements like this is, do you think this restrictive covenant would be enforceable? Do you think that, that this 5-mile range or 10-mile range from wherever is something that would hold up in court? And the answer is that it's often hard to tell. We certainly have some experience that we can bank off of, and we have some examples that we can call from to try to make an educated guess at what's enforceable. But the point is that it varies wildly based on the geography of where the practice is. To go back to the previous example, 5 miles from every office may be a reasonable restriction in a more rural area, but a 5-mile restriction from an office in Manhattan, for instance, would be ridiculous. And so for that reason, we need to have background on exactly what type of job that you're agreeing to tell you whether or not something would be enforceable. And perhaps more importantly, even if something would not be enforceable in court, in theory, it's still not something you want to agree to, because to have litigation over a restrictive covenant, or really any of these deal terms, is very expensive and very time-consuming. And so you want to make sure that you're not agreeing to anything, no matter what, that you wouldn't be happy fulfilling or upholding. So another way that we can try to get restrictive covenants cut down, just as an example, we had a client recently who moved to a different state for her job. She moved, I think she lived in the Northeast, and then she moved to Florida, so she moved very far away for her job, and immediately figured out that it just wasn't for her. There was not the type of job that she was anticipating. They wanted her to work completely different hours than what she was expecting, and she wanted to leave after working there for 6 weeks. Now, the problem with that is that she'd agreed to a restrictive covenant saying that she wouldn't work within 10 miles of any of the offices there. So now this cuts out a gigantic geographic range. She can't work anywhere where near her new apartment is in this totally different state where she doesn't have contacts. So something a way that we would try to counteract that is to say that, oh, well, maybe the restrictive covenant won't kick in until you've been working there a year. To go back to what the employer's goals are with these restrictive covenants is that they want to keep you from establishing patient relationships and then taking them away from them. So if you haven't been there for very long, then maybe you're less of a threat to them, and maybe we can try to cut it down in that way. And that's just one example, but because the wording in these restrictive covenants can be so vague and so varied, it really is very position specific, and which is one of the reasons why it's important to talk to an attorney when you're considering these employment agreements. Now, so that was just one example, but to go back to where I started, which was the what, where, and when of your employment, here are some other factors, some other terms that should be included in your contract. Now, these are just a few examples, but the location, you obviously want to know where you're working. An employer, again, will probably try to keep this as vague as possible because, again, they may expand while you're there. Even if they have, only 2 offices when you join, they want to make sure that they can send you anywhere that they're going to need you. But for you, if you're moving for a job or if you take a job because it's very convenient, it's very close to your home, then location can be very important to you. You might want to write into the contract, oh, I am agreeing to work at location A and location B, but anywhere other than that, I have to consent to. And that's something that we can try to negotiate. Similarly, with schedule, this is another thing that employers will try to keep vague. They want to make sure that they can have you work whenever they need you. But by the same token, you may not want to work the overnight shift. And as I think Erica alluded to earlier, especially as a young doctor, as the lowest person on the totem pole, as the first person in the group, you may often get the worst schedule and the worst call shifts. And you want to make sure that the employer can't take advantage of you. So these are just a few examples. And finally, with negotiation tips, the biggest tip that I can give any doctor who is negotiating an employment agreement is that it's worth it to try. We get clients all the time who talk to us and they say, okay, well, I understand all these contract provisions now. I see what I'm not happy with and what I would like changed, but what is really the likelihood that I could get anything changed? And the answer is, I don't know, but neither do you, and it may be more than you think. In most cases, it's worth it to ask, and usually the worst thing that would happen is that the employer will say no. But the first thing that I can tell new doctors who are negotiating agreements is that you may be surprised by how much you can get and what an employer would be willing to do for you. So with that, I am going to send it back to Jennifer just for some final thoughts.
Thank you, Richard, and thank you, Erica, for time spent on these very important issues related to my first employment agreement. I want to thank everyone for joining us today and just add that there are additional resources available for you that are free before you contact us with your first contract on our website, which is there, nyhealthcareattorneys.com. Also, I'll show you another, we have a bunch of other URLs you can go to, but that's usually the easiest for doctors to remember. When do you need to call your lawyer? It doesn't necessarily have to be when you get your contract. If you're listening and if you've heard us speak at your program, we'll tell you that you can call us anytime if you have questions on the negotiation process or you're concerned about terms. Feel free to reach out. If you're given a letter of intent that they tell you is not binding, do not be disillusioned or think that this is not important. This is the stage where your terms for your contract and your inevitable employment will be set and must be negotiated at this time. Just because it's non-binding, if you wait until the contract is actually issued to say, hey, you know what, I'm not comfortable about that restrictive covenant, or I don't really understand how the bonus is going to be calculated, the employer may actually feel that you are dealing in bad faith, that you didn't bring this up at the initial instance when it was discussed with you, and that this has already been negotiated. So we suggest that if you do have questions on negotiability or terms that are actually being set forth, that you do contact us before you get the contract when you do get a letter of intent. That being said, I don't really believe in letters of intent. It's just an agreement to agree and a contract before the contract, non-binding or otherwise. So I don't really care for letters of intent. Let's just see the contract. I've seen employers change deal terms from the letter of intent to the contract, and they may or may not even notify you. So I don't believe that it's important to have a letter of intent. But if you do, we're happy to look at it for you. One of the first questions we always get is fees, which I'm happy to tell you about because we haven't changed our policy in over 9 years on fees for the employment agreements. Okay, we do the employment agreements for residents and fellows for the review only for a flat fee of $500. So with each contract, and that's for an individual contract, we charge $500 for the full complete review, which is a comprehensive analysis of your contract, a write-up. If you don't want to write up, we don't have to do it, less time for us. We'll make actual contract changes to the document if you have a Word version. And then we do a discussion with you, or you can do an in-person meeting with us if you want to come to our office. And we'll be happy to go through each point, line by line, an interpretation or analysis of your agreement and recommendations on where we think that you should go. Of course, any decision on terms is your call, what you're willing to accept. And they say that any good negotiation is when both parties are moderately unhappy. So if you feel that you've gotten a pretty decent deal and the employer feels like they're getting a pretty decent deal, then you're probably ready to start your job. That's if you want that job. So with that, there's plenty of more things that we could add, but I think I'll end on that note and let everyone return to their day. Erica, Ricky, and I are all available to do in-house education, which we regularly do at programs. Of course, that is easier for local programs. But if any of you wonderful hospital administrators want to fly us out to San Francisco, we're available and happy to go. So I'll put this screen up. You can contact, that's my contact information, but Richard and Erica are available at the website. Again, the nyhealthcareattorneys.com works, and so does this link below, the Kirschenbaumesq.com. You can sign up for our newsletter on the website. We do a free Q&A twice a week for physicians every Tuesday and Thursday, and you can write in and send us questions. We're happy to answer them. If you have any questions about this topic, or you are receiving your contract and you need assistance, you know how to reach us. We hope everyone enjoyed the webinar, and we look forward to providing additional topics for you soon.